Hi, welcome. As was just said, my name's Claire Tooley. I work in Chattanooga's Baker office, but I'm here in Nashville a lot. And yeah, 90% of my practice is transactional. I occasionally touch regulatory work. I sometimes have to do a little bit of litigation work in the early stages before it gets passed on to someone who actually knows what they're doing. And actually, prior to going to law school, I was a paralegal at Baker Donaldson, also doing transactions. So I have seen pretty much every angle of a closing. And so today, we're going to be talking about how to get to closing. And so I'm going to talk about closing deliverables, sort of common disasters that if you haven't already encountered them, you will at some point. And then not so common actual disasters that are like a stop everything moment. When I'm talking about closings and deals, assume that these are purchases or sales of a business and associated real estate. You'll hear me bringing up title companies a lot. If you're dealing with a purchase of just personal property or like a membership interest purchase, take out that title company element, it's usually going to be opposing counsel that you'd be delivering things to. I am not going to cover loans, really. That is its whole own separate hour. So I'll briefly mention them, but I won't be diving deep into that. Maybe that's Business College 102 next time. All right, so your client finally signed a purchase agreement after weeks of negotiations and hundreds of drafts. Now, how do you close it? And your first question might be, if you're new to this area, is what exactly is a closing? Now, most transactions are kind of two distinct events. There is the signing of the purchase agreement, and then the actual closing where you exchange money for real estate and or a business. A sign and close, where the parties sign the purchase agreement and close immediately thereafter, is pretty rare, primarily because there's a lot the buyer needs to get done. I mean, we're talking about maybe a $2 million business closing, but think if you bought a house, you had to get inspections done. You had to figure out your lending situation. Business buyers have to do that as well. And so by having this period where we've signed up a purchase agreement that sort of sets forward the rules going forward, the buyer is able to take the time to do their due diligence, get their financing in order without having to worry that the seller is going to shop this around to someone else and take the deal out from under you. And it also gives the seller comfort that the purchaser has deposited some amount of earnest money, they're diligently working towards this, and they're not going to string you along for hundreds of days to get this closed. And so typically, that period between purchase agreement and closing is going to be anywhere from 45 days to 90 days, maybe even longer if there are certain regulatory approvals. And so during that in-between time, what are you doing as an attorney? So the first item, which is the big one, is due diligence. If you're representing the purchaser, really talk with your client about what their expectations are for your involvement. Now, obviously, I don't know about you, I can't read a financial statement. Like, I am not going to be helpful in looking at 5 years worth of profit and loss statements. But I can read a lease, I can read a contract, can let them know what the assignability provisions are. So talk to your client about if that's something they want help with. A manufacturing company with 100-person administrative office, they probably don't need your help on that. They have someone whose job it is to read those things. But a small business owner who is expanding into a new location and has to run their existing business, they might find your help worthwhile. So early on, when you get the diligence list, say, hey, what do you want me on here? And then check in, because someone could have great intentions to do some of that diligence and then just drop the ball. So make sure you're keeping a communication open. And now, if you're representing the seller during due diligence, you're probably not doing much. I feel like most of the time I'm just adding people to data rooms that we've set up on the purchaser side and herding cats in terms of getting information over. You also might be working on license and permit applications. Depending on the nature of the business, the buyer might have to apply for certain licenses, like a county business license, which is really simple, or something a lot more complicated like a liquor license. Again, this is something where talk to your client about what they want you to do. Some people do this in-house. They might hire a consultant who specializes in this, or they might want you to do it. If they want you to do it and you've never done that type of licensure application before, please partner with someone, find another attorney in your office or find someone through the Bar Association who can walk you through it. These applications are oftentimes very difficult, and any sort of mistake on your end can delay the process for the client. Licenses and permits can often be long lead time items. Go through your purchase agreement and try to identify other items that might take a while to deliver. I am assisting on a transaction in Alabama right now. The seller is required to get a certificate of tax clearance from the state. I looked up how long that takes to get. It's about 3 to 5 business days. Talking to the paralegals in Birmingham, it's like, depends on the time of year. It could be more like 10 business days to get it. That would be really bad if I decided to order that the day before closing and found that out. You have to hope that buyer either waives the condition or you're delaying closing. So, go find those items and then put them in your calendar. Make a critical dates list, not just of those sort of, okay, I can't do this by any later than this date deadlines, but also deadlines in the purchase agreement. I'll go through and read it, and anything that is, seller must provide within 10 days of execution or no later than 5 days before the closing date, buyer must provide. I will find those and I will put them in a calendar. I will add reminders. I will CC other people on the reminders just in case I get hit by a bus, because there are a lot of times easy deadlines in there, and if you miss them, you're really creating not a great relationship between the parties. If my buyer owes the seller a list of contracts that they are not going to assume at closing, and they blow past all those deadline dates, and now they can't timely terminate those contracts, they're gonna be mad. And this is not an adversarial process. That's what I love about transactional law, but you're making it adversarial if you let them miss those deadlines. All right, so once you've gotten through all of these things, and it's time for closing, what do you actually need? What are the must-haves? I've called these deliveries because they are literally going to be delivered somewhere probably. In-person closings are really rare now. You might still go to them occasionally, especially if you have like a more rural client, but even pre-COVID, we were not going in person to a title office to close that many things. And COVID really sped that up because a lot of clients were able to see, oh, my attorney can close this like from their home office. I don't need to be paying them to sit in a title office for 8 hours to do essentially 2 hours of work. So what you'll do now is send everything to the title company with very clear instructions on when it can be released. Once the title company confirms that they have all these documents, and more importantly, they have the money, they'll say, hey, we're ready to close. There will be a flurry of emails for everyone saying, I, on behalf of seller, hereby authorize you to close and record documents. And then title company records documents and disperses funds, and you're done, all from the comfort of your own desk. So what are you sending to escrow? Now I have up top there signature pages, because I think they're almost more important than the documents themselves. There are several ways to get signature pages from your clients. Some are going to want you to print them every single page of every document, and they're going to read through it. They're going to come to your office, read through it, and then sign things. Some clients have read these documents to death. They can tell you what document it is just based on the signature page. They don't want to deal with all that paper. Send them a PDF of just signature pages. They'll print it out. Don't worry about it. Now, I did just mention PDFs there, so what about electronic signature pages? Are we actually printing and signing things? So overall, electronic signature pages are a lot more accepted than they were before. Again, this was a COVID thing. But also, secure methods of electronic signature have really risen in availability. Because when I say electronic signature pages, this isn't like where you go into PDF and you can like stamp a signature. This is a secure link from something like DocuSign that comes, they electronically sign, you get a certificate of this person at this IP address signed this document at this time. It's pretty much as close as you can get to someone being in your office and signing it. Before 2020, I was getting 2 sets of original of every single document because I'd send one to opposing counsel, hold on to the other because the client didn't actually want the original signature page, but they still want to send it to me, and I was just drowning in paper. Now, as long as the client and opposing counsel agree with it, we can close on PDF electronic signature pages of pretty much everything except loan documents are the big exception there. Those have not moved to electronic signature pages. I do not see that happening anytime. Recordable documents, even if a county has e-recording, the title company wants to see the physical original signed document, and anything that gets notarized. Those are going to be your exceptions, but I mean, if you're seller's counsel and you don't have loan documents, being able to use electronic signature pages cuts the amount of paper you're using into like a fifth, which is good for you because you can be more organized. It's good for the client because they're not paying to send signature pages all over the country. So it's a win-win. Now, as to the actual documents, we're talking about real property. Obviously, you need a warranty deed. We all remember that from property class. You're also going to need an owner's affidavit. This is a document you'll get from the title company that gives the title company comfort that they can close because the seller certifies to matters that aren't public record but can still cloud title, like unrecorded purchase options. You don't have to worry about someone saying, I have this agreement that I actually could buy this first. They'll say, we haven't had any work done in the past 90 days that could give rise to a mechanic's lien like a week from now. That hasn't been recorded yet. So make sure your client really reads that closely. Obviously, they should read every document closely, but sometimes they'll be like, they'll see construction work and they're like, well, we haven't had construction work done yet. It's like, well, but like, did you get the driveway repaved? Or, did you even like install a bench? Anything that counts as work that could lead to a mechanic's lien. That I feel like is always the one where it's like, you got to dig in there. If the asset includes personal property, you'll need a bill of sale. It's essentially like the personal property version of a deed that transfers everything except the land. Super simple one-page document, just saying seller sells and conveys to buyer all of its right, interest in, and to the personal property, the end. You'll need a FIRPTA affidavit. Title company is going to need this. If you're representing the buyer, you should insist on getting one as well. FIRPTA stands for the Foreign Investment in Real Property Tax Act. If the seller is a foreign company or foreign person who does not otherwise pay taxes in the US except on property, the purchaser has to withhold 15% of the proceeds, and they will pay that to the IRS after closing. Because by God, the IRS will get its capital gains tax, even if you are literally leaving the country afterwards. Now, 99% of the time, you are not going to need these, or you're not going to need to withhold proceeds. This has happened to me once in 8 years of lawyering and 3 years of paralegaling. So what you do instead is get an affidavit where the seller says, my company or I myself am not a foreign person in any definition within the IRS. Title company keeps that in your records. You should as well, and you're good to go. Now, we heard earlier about corporate authority documents. And so if you have an LLC, you have a corporation, everyone's going to need to see those documents, including you yourself as the client's lawyer, because you need to know that the person signing that deed on behalf of the company actually has authority to do that they aren't just like a rogue member doing this. And so typically how you prove that up is you will have an officer certificate or an incumbency certificate, and someone in the company will certify, hey, here are articles of organization and operating agreement. These are true and correct copies. There are no amendments. Here are resolutions signed by all the owners of the company saying, yep, we agree to this transaction, and this person can sign as manager or president or what have you. And then a certificate of good standing showing that all those annual report fees we were talking about earlier and F&E taxes, companies paid those, company still exists within the state of whatever the state is, you're good to go. So that gives everyone comfort of, yes, we can proceed with this transaction and with this signatory. If the property has an existing mortgage on it that's being paid off, obviously you need to see that payoff if you're the buyer. Typically, I have found a lot of banks are weird about sending deed of trust releases and other lien terminations before closing. Like they really want that money in their bank account before they start that process, which makes sense. So instead you'll get a payoff letter. This is helpful because It actually sets forth the amount due, so the title company can put that on the closing statement, but also says, or should say in very clear language, upon receipt of however many amounts of dollars, we will properly record all releases. So you need that very clear language, and that should get the title company comfortable to close over not receiving the termination documents. And then finally, you'll have the closing statement, which determines the flow of funds. Now, if you are doing, transaction of just raw land, your closing statement's gonna be pretty simple. It'll be purchase price, tax proration, and then all the title fees. But if you are doing, purchase of an ongoing business, you have a lot more to go in there, like rent if it's leased property, employee pay, utilities, and those are things that can change daily. So if closing slips a day, you have to recalculate that. And also some of those things are difficult to calculate in of themselves. Rent's pretty easy, but employee pay, someone could quit. Someone could take a day off, and so that impacts like PTO transfer. And it really is impossible to get right. So your purchase agreement should include language that within 45, 60 days, all the parties will come and they'll true up that closing statement. Someone will write a check to the other side. Usually I find it's kind of equal, like both sides have overestimated. So usually both sides are writing a check to each other, which makes it a little easier. And you also need to make sure that your invoice is on that closing statement if you're getting paid out of closing, and not just for legal fees, but also if you incurred any costs to third parties in connection with it. If you ordered a good standing certificate, put that invoice on there. It's a lot easier to get paid at closing than a month later. All right, so these are the might-haves after we had our must-haves. These are things that you might run into depending on the type of transaction. First is an assignment and assumption of contracts. If this is an ongoing business that has a lot of vendor contracts or third-party contracts, and the buyer wants to assume some of them, this acts as a general assignment of those and really supplements whatever the process is under the contract itself. And it's a reference for all parties after closing of, okay, what did buyer assume? What does seller terminate? Because you'll have a list on the back. And it can even be helpful years down the road. Had a client who bought a facility, a few years later, a vendor who the seller didn't properly terminate that contract, came and just tried to sue everyone, new owner, old owner. And I was able to go and pull that assignment of contracts, like, we didn't assume that one. So we were able to get out of that case pretty quickly. If the premises are leased, buyer's not assuming that lease, you'll need a termination. Seems pretty obvious, but I feel like a lot of times sellers will say, oh yeah, we terminated it. If you're the buyer, ask for a copy of that, just in case. A vehicle bill of sale. Now you can transfer vehicles through a normal bill of sale, but you still have to go to the DMV and get it retitled. And I have found sometimes county clerks, DMV clerks, they like a little extra documentation. And again, just a one-pager of seller hereby sells to buyer this 2010 white Sprinter van, VIN 12345. That can help move along the process. It's not that hard for you to document. I like to think of it as like a value add for the buyer. If the buyer is acquiring a going concern and wants to keep the name, because of the goodwill associated with it, you need to do an assignment of the trade name, which the seller says, we are selling this trade name to buyer, they have exclusive use of it, and they agree to timely file their cancellation of their trade name so the buyer can file their own. Non-competition agreements are obviously a CLE in of themselves, but I have it here because there's a chance that you might run into them. Because non-competes show up a lot for the individual owners or like principals of a business if they are selling. That FTC rule banning non-competes never went into effect, but I did find it interesting that every iteration, it always had this carve out for sellers of a business, that non-competes could apply to them. Because if I buy a hair salon from you, and I know it's the only hair salon on this side of town, and I'm basing my financial projections on this being the only hair salon in town, and then 2 weeks later, you go down the street and open up your own, and you see all my employees, not my clients, it's really not fair. It's the sort of thing that you expect people to act in good faith, and so you will sometimes see non-competes come up to protect that. I would say I've seen them about like a third of deals I work on, so just something to be aware of. Then you might also have a post-closing escrow. This comes up when one party, typically the seller, has things they need to do after closing. You're gonna get a lot more examples from me on post-closing escrows, but a starter one is, let's say a seller ordered a new generator for the property, but it's back ordered. It's not gonna be available until after closing. Purchaser doesn't want to pay for the installation because they didn't order it. It benefits them, but they might have wanted to order a different one. And so usually what will happen is the parties agree to take the estimated amount of paying for the generator and installation, put it into account with the title company. All three of those parties enter into agreement of this money will be used solely for paying for this generator once it comes. Anything left over goes to the seller because it's going to come out of their proceeds. And this also means that seller can't just abandon the work. Like they've put that money in there, it'll get done one way or another. I will say that when escrow agreements come up for situations like this, it's a compromise that no one's truly happy with because the seller's mad that their closing proceeds have gone down in some way. And the purchaser's mad because they're always trying to get a cut on the purchase price. So the fact that no one's super happy with it, I feel like means it's the best compromise, but just know that you might get some pushback from your client on that. These are a few additional deliveries that aren't really documents, but should be on your radar. Your purchase agreement will likely have disclosures made by the seller. These are either exceptions to the representations and warranties, like the business is not subject to any litigation, except as shown on Schedule 1.2, or to attach information that is just awkward to put into a document, like a list of tenants in an apartment building. No one wants to take up 3 pages in a document for that. Because we have that gap between signing the agreement and closing, you'll want the seller to update those just in case anything has changed. You'll want to give notice to vendors that their contract is being assumed or terminated if you're the seller. Had a client who sold pretty much their entire portfolio of assisted living facilities one year. And because of that, all of the back office staff went to go work for the buyer, which was great, they kept their jobs, but it meant it was like a real skeleton crew with the client, and no one ever sent notices of termination. So for years we were dealing with, literal years, vendors showing up and being like, hey, we kept delivering PPE for 6 months and never got paid. And so they had to deal with a lot of settlements, and it was not fun. When I said I sometimes have to work on litigation, that is the kind of thing I mean. So if you're representing a seller, really hammer home to them that it seems like an annoying step, but they gotta send out notices. Even give them like a template of notices where it has their letterhead and it's just, dear blank, as of April 1st, we will no longer operate this business. We are terminating your contract. Please forward all further inquiries to whoever. Super simple. Impress upon them that it could cost them money in the long run if they don't do it. And then finally, if it's a business, the transfer of the records. If these are paper records, it's really nothing to do. They'll probably sit in the same file cabinet that they have always. But if it's electronic records, make sure your client knows how they're getting from computer A to computer B. I deal a lot with electronic medical records. Those software companies do not make it convenient to move to one of their competitors. We always joke that point-click care sets your closing date, not anyone else, because they will make it unpleasant for you. All right, so you've got all your deliveries together. They're in escrow. What could possibly go wrong between now and closing? Many things can go wrong. There are too many people involved in a closing and too many moving parts for it to go off perfectly. Every closing is going to have its very specific issues. Every closing is horrible in its own way. But the more deals you do, the more you can kind of like identify things ahead of time, try to stop these pitfalls before they happen, and hopefully just get around them entirely. I've organized these into a few categories. The first are title issues. Now I feel like transactional attorneys and litigators always act like we're the most different people in the world, but I do think one overlap is county formatting requirements. For litigators, it's that one county has a weird way you have to submit a complaint, and for transactional attorneys, it is like weird margin requirements for deeds. And so you don't want the title company to get your signed deed and say like, oh, this county requires 4-inch margins on the signature page and also like a 10-inch margin on the cover page for the stamp, you're gonna have to re-sign this. That is the worst case scenario, basically. So always, as soon as you got drafted, just send it to the title company, be like, hey, does this look good? Are we good to sign? And get them to confirm that. And even if you're like, oh, I did a closing in Shelby County last year, I think I'm good, I'll just use that same form, double check, takes 5 seconds. Some counties or cities also have additional closing requirements, like a special cover sheet that you have to use for filing, or proof that the seller is a resident of the state where the transaction takes place for tax purposes. Ideally, these are in the title commitment that the buyer gets and will send to seller a copy of, but sometimes they're not, especially things like cover sheets, because they just consider that part of the deed and don't think to mention it. So I will usually, getting close to closing, send to the title company a list of all the documents that I know we're providing on both sides, and CC opposing counsel. Just be like, hey, here's what we're sending you. Is there anything else we need in order to close this transaction? And make them answer you, because again, you don't want it to be the day before closing and someone's like, oh wait, did you not send us this? Yeah.
Do you find that, I know there's like those title companies and banks, you've got a lot of non-legal requirements where you're like, oh, law says this, but they've got their own way they want things. And I know your job is to get this deal closed, but are there certain things that you will push back on where you're like, there is no reason we should have to jump through this hoop, or not so much as you just want to get it?
It really depends. I just got an email from buyer's counsel asking for something that their lender needed, where it was providing proof of the seller's payment of employee payroll taxes. And client was really pushing back at that, I think partially because they've been getting a lot of requests from this buyer, and so they're a little over it. And I was sort of like, I've never seen this request before. So I went up the chain to one of my mentors and was like, hey, they're asking for this, can I push back? And he was just like, well, it's definitely weird, but I think the reason they're asking for this is that sometimes the IRS will go after the new employer for failure to pay payroll taxes, even if they didn't do it. So that's probably, they're like, this bank probably has been burned before. That's why they're asking for it. Recommend that you give it to them. Had to go a couple of rounds with the client on that, but they finally delivered it today. I think as long as it's not truly an ethical or legal issue, try to find a way to make it work, or at least a compromise. Some sellers are really sensitive, understandably, about giving out too much information about their employees ahead of time. And so we'll redact, obviously we'll redact things like social security numbers, but we'll even redact names early on, because buyer doesn't really need to know that at this stage in due diligence, like they haven't hired them yet. They really just want to see what are the categories of employees and how many there are. So I think it's find a compromise, try to work towards a good solution, but yeah, generally I'm not gonna outright say no.
It sounds like pick your battles.
Yes, exactly. It's very much pick your battles. And that sort of leads into the next thing of unresponsive third parties, which is another time you have to pick your battles, because sometimes the title company is going to be your unresponsive party. I love title companies. They get things done, but they're also extremely busy. And so it is hard to get on their radar sometimes. And so if I'm gonna call them up to get an answer about something, I try to do everything at once and like the important things too. So I'm getting their attention on the thing that is most important in that moment. But usually picking up the phone there will be a huge help, because they get more emails, I think, than we do. So just gotta get on their radar. And the nice thing about the title company is that they are invested in the deal, because they are going to get paid. But other third parties aren't. They're just there to be helpful, and they don't have to be helpful if they don't want to. And I see this a lot with estoppel certificates. These are usually required when you have another party that is in a contract with one of the buyer or the seller, usually seller. So something like a lease, where if buyer is buying a strip mall, they're going to want certificates from the grocery store, the dry cleaner, et cetera, that, hey, this is my current rent amount that I pay. I'm not in default in the lease. The landlord isn't default in the lease. I'm attaching a copy of the lease for reference. It's a pretty simple document, But it can be really hard to get because you have to find the person who can sign it, and they have to make time to read it and sign it. They might want a lawyer to look at it, which is of course their right, but then that again drags out the process. Had a closing recently with representing a borrower under refinance, and the lender wanted a certificate from the Professional Owners Association, just like the office park version of an HOA. And no one there had ever met anyone from the association. They sent a check to a PO box somewhere. And so we found out they had a website where you could submit requests like this, and they promised to get back to you within 45 days. So that sort of thing where it's like, you can't really rush that. So when you're talking about long lead time items, definitely look into that early. You don't want to get your certificate signed 60 days before closing because then it's sort of useless. But at least like identify them, figure out what the process is, let them know it's coming, and hopefully you can move it along at a good pace. Final thing is governmental entities. We talked about licenses and permits, but what if you need to get a subdivision of the land or it needs to be rezoned? Again, you're on the governmental entity schedule, not anyone else's, and this is where you can really lean on your network. Because maybe someone in your office knows a guy in the planning committee and can get you in touch. Or you met someone at a networking event who used to work for this agency and still has contacts there. Get your client to call, because a lot of times the business guy gets things moving that the lawyer can't. And if none of that works, again, pick up the phone and call. Some departments won't talk to you, they're weird. They like everything must be in meetings and in writing, but some are willing to set up a call, get to know you, find out what the issue is, see what they can do. With all of these, you can't just keep sending emails into the void and hoping for the best. You have to be proactive. And signature pages are their own sort of fun category of closing issues. The first is when your signatory is not available. Back when I was a paralegal, got a call from the client who said, hey, no, we're not closing for 3 weeks, but could you get me signature pages tomorrow? I just got invited to go climb Mount Kilimanjaro, and I'm leaving for Tanzania in the evening. Cool. We didn't even have some of those documents drafted yet, so I had to spend a very fun day putting those together so he could basically come in on his way to the airport. It's obviously a very extreme example, but you have to be prepared for your client to not be around. Because while you think that this is the most important thing that they have going on, it's probably not. They have vacations and religious holidays and medical procedures that they can't really plan around. And so just as we can't give 24/7 availability to them, they can't give that to us. So I will ask early, 3 weeks out, of hey, John, who's signing, does he have any vacations planned? Is he gonna be out of town? What's his schedule? Because ideally, I like to get signature pages out 10 days before closing. That's kind of the sweet spot where it gives us a little bit of extra grace period if they're not ready to sign that day. But by then we usually know the universe of documents. It's a final set. And if they say closing the 30th, he's gonna be out of town, the 20th through the 28th, and then I'll be back in. It's cool. I'm sending you those signature pages on the 19th because I don't want to worry about his plane's delayed or he decides to take an extra long vacation or he's sick. Get him to him early. And then also try to get the client to authorize an additional signatory. Some are weird about this, but just really push them to be hey, just as a backup. We don't expect them to sign anything, but they're there if we need them. Because that helps with anything that comes up last minute. Now, even if you do sign documents early, you have to be careful not to miss any signature pages. This thankfully has not happened to me in a while. I can perfectly recall the sinking feeling of sending signature pages into escrow, the title company or opposing counsel saying, oh, hey, I didn't see this signature page. And it's for a document that I forgot about or I did not even know existed until that moment. It's not a good feeling. Now, the good news, as we talked about, is you can either send it for DocuSign, done, they can do it from their phone. If it needs to be original, sometimes title companies, as long as it's not the deed, will usually close on a PDF and here's the FedEx label showing it's gonna be delivered to you tomorrow. Hopefully no one is gonna hold up a deal over the fact that title company doesn't have the original FERPTA in hand. You can usually smooth over that. But if it's a loan document or it is the deed, I don't know how you would have missed that, but I'm sure it's happened. You just gotta eat crow and tell your client, I am so sorry, I missed the signature page. We need to get this re-executed, and try to make it easy for them. If it needs to be notarized, send a notary to them, or offer to have them come into the office. Give them a label to use for shipping so they don't have to stand in line at FedEx. They can just drop it off. Just really make the process easy. And so how I don't miss signature pages now, on a pretty good streak, is making a closing binder index before closing. So this will be a list of all the documents, and it kind of is good to see everything laid out. Lets me think, okay, is there anything missing here? I will flip it to whoever else is working on the deal, other attorneys, paralegal, because there might be an email I missed or wasn't CC'd on, and they can add things in. And then it also acts as a checklist when you're putting together the packet. And so you can usually, make sure you've addressed everything that way. And then, of course, you have the most comprehensive index in the world, and be sure you have everything signed. And then there is a surprise new document. I see this happen two ways. The first is a late breaking issue presents itself. For example, I was working on a deal where the water utility placed a lien on the building a few days before closing. Seller had forgotten to pay the bill. It was like purely a clerical error. Didn't mean it to happen. They had already paid it by the time the lien had been placed, but we weren't going to get that lien undone in time for closing. So what happened is title, who couldn't close over a lien like that, said, put the amount of that bill into escrow. We'll hold it there. As soon as the lien is released, seller, you get that money back. We were able to close over it. So it's an easy solution, but not the sort of thing you knew about ahead of time. So there's that. And then you might also just have opposing counsel who is not on top of things, who did not make a binder index. And so they might pop up and be like, oh, hey, totally forgot that our lender needs the seller to sign the signature page, and they need 3 originals. Can you do that? Or seller's like, oh, I'm doing a 1031 exchange. Didn't realize that the buyer has to sign something. Here you go. There's really not much you can do about that. I try to say to the other side, hey, I'm getting things signed today. Is there anything you need me to add in that we haven't already discussed? But, once you do that, it's in their court, and you have to hope for the best. And because there's not a lot to do about it, you have to know who's going to sign last minute. That's why you want that backup signatory just in case. And also, try to inject some calm into it for your client. Concisely explain to them what the document does, why you think they need to sign it, and again, organize signature however best you can. And then one thing, just realizing, did I talk about breakaway signature pages? I don't think I did. So that can go under closing pitfalls. Ideally, all of your signature pages should be on their own page separately. It'll just say on the top, in witness whereof, as of the effective date, the undersigned hereby executes this bill of sale, that's it. Because if you don't have a page break, you have body text on that page, if they've signed a week before closing, but the document's still been changing, even if it's just like, oh shoot, we had a duplicate sentence we need to delete. Now you have a signature page that doesn't match the final document. And that can be the sort of thing, that is a disaster in of itself, because you can be pairing things up and just being like, what happened here? Like, why are there 5 sentences on the top of this page that my client signed, but 2 on the final? And so if you have the breakaway signature page, makes things very clean, very easy. You don't have like version numbers on it if your document management system does those, because again, you don't want them to sign something that says version 5 and then the final is version 8. Really try to make it easier for yourself so you can just gently drop them into the final documents. All right, and so talked about everyday disasters, but what about actual disasters? The first is unexpected expenses. And this is not just a client who's like, oh, your invoice is too high, or like, oh, I really have to pay that much in transfer taxes. This is an expense that no one accounted for and can really derail the deal. This happened to me literally last week. A client was selling a long-term care facility that had a really great government-insured loan on it that had wonderful interest rate. So the seller and the buyer had gone through the process to transfer that loan from the seller to the buyer. One day before closing, or what was supposed to be closing, I get a call from buyer's lawyer that under the loan agreement that the seller had signed, they had certain repairs they needed to make by the end of this month. They had not, or they had even put money into an escrow for that to make those repairs. They had the money there to do it. They never did it. And so because this loan was transferring, the repairs almost like ran with the land. They were now the purchaser's responsibility. Purchaser, understandably, did not want to spend that money on something that was the seller's responsibility and that they thought had already been done. And so what buyer proposed to me was, your client's supposed to get back that repair escrow that they didn't use. Instead of getting it as proceeds, let's put it into an escrow account with the title company, and we will use that to make these repairs. Now, this was a multi-site deal that had closed in different stages. This was the last stage. And seller wasn't getting a lot of proceeds on this compared to the other ones. And that repair escrow was $250,000. By taking it out of their proceeds, they now had to bring over $100,000 to closing. They were losing money on this deal. Now, they were very lucky that they had money in their account that they could meet this cost. They were really upset about it, but they were able to do it. But some sellers may not be able to, because there may be something like this that they failed to do, or there's a catastrophic equipment failure that they have to repair, or else the property is not usable. Or there's a tax lien that they have to pay. And this isn't just a seller thing, because for the buyer, their lender's appraisal could come in low. And now the lender says, we'll make you the loan, but it's gonna be $1 million less than we said. And so now they have to bring money to closing. And there are some people who they just cannot meet this economic burden, and they're gonna come to you and say, what do we do if we can't close this deal? Now, these are financial questions. No one is expecting you to whip out a model of how they can increase revenue. But what they are expecting you to do is answer that question of what if we don't close? So reread your purchase agreement front to back and be ready for that conversation with options of either you'll lose your earnest money, or buyer might sue for specific performance, or any other possibilities that are in there. And yeah, just be ready to advise them, and then paper it however you need to. Now, deals are obviously primarily about money, but bad financial situation is put into perspective by this next one, which is the death of a party. This did happen to me once. It was very early on in a deal, so it didn't derail things, to put it crassly, but it was a nonprofit. One of the board of directors passed away suddenly. He was sort of the lead of this nonprofit, and it was a really sad time because it was someone we had worked with, and business partners were grieving. And when you're in a situation like this, you as the lawyer are going to feel like an absolute jerk, because you're gonna have to show up and be like, hey, so our deal, we still gotta get that closed. Because the thing is that your contract can't just be paused indefinitely. It has to close at some point or terminate at some point. And so as awkward and awful as it feels, you have to keep things moving. So if this happens, the first thing to do is find out who does that individual's estate planning. Obviously, it's great if it's someone in your office. That makes things convenient. But if it's not, you're gonna have to ask and find out, which again is gonna feel awkward, but present it as, I need to let them know about this deal because it could impact the administration of the estate. And so once you talk to that estate planner, let them know that this deal is happening. Ask about appointing a receiver. Does anyone know about Tennessee's business receivership program? Do you want to give a quick summary, or not to put you on the spot?
I just attended a CLE where they talked about it, and it sounds really cool.
Yeah, so this is, I think, a first in the nation program that started in Hamilton County, because some of the chancellors noticed that when the principal of a business died, oftentimes the business, which is this obviously huge asset to the estate, would just flounder and even fail because the family members or the other didn't know how to run it, or other business partners were fighting over it. And so set up this program where, kind of similar to a guardian ad litem, it's a receiver for the business who comes in and takes care of the business and helps keep it running and maintains the status quo, which can include selling the property. My colleague in Chattanooga, Jennifer Exum, does this a lot. And she just last week sold a Dairy Queen that she has been helping run for a couple of years. And that was one where it took a while to find the right buyer. It wasn't even for sale at the time. I did help her with the owner had been looking to buy a second Dairy Queen, and he died during that process. And she came to me, she was like, is there any way they can get their earnest money back? And so I had to look through that contract. Eventually I was like, no, they gotta lose that earnest money to the seller. But what's great about this receiver is that in addition to keeping the business running, they're the ones who can make those awkward decisions with the business partners, with the family. They're your intermediary. And it leaves you to run the deal. Now, obviously, this is gonna delay things, especially if it happens late in the process. But I like to think that all of our colleagues in the bar would be understanding in the situation, get that it's really unusual, and not be like, no, we had a drop dead closing date of April 30th, and if you don't do this, we're gonna terminate. You might have to paper it to a certain extent, but I think people will get, as long as you are actively working towards consummating the transaction, they'll give you some grace in this situation. And then the final disaster is what happens if the property is not there for closing. Fires, floods, hurricanes, these things are pretty rare. I would say hurricanes, especially so in Tennessee, but they can happen. And you need to be ready for that. The good news, to again be a little crass, is that if the property is completely destroyed, it's very easy for you as a lawyer, because most purchase agreements will have rules in there for, okay, if the property is completely destroyed, what do we do? Typically, it's either buyer can terminate, get back their earnest money, or purchaser can move forward with the deal, but they'll get an assignment of the seller's insurance proceeds. So really easy for you. That's a business decision. You'll defer to the buyer. Might have to paper something, but not much to do. If it's less than total destruction, it gets a little more complicated. Because first of all, you may be fighting with the other side about if it was a material destruction or not. If you're representing the seller, you want very clear language in there on what's material, like a percentage of the building footprint, or repair estimates that are a certain percentage of the purchase price. You want it to be clear of like whether it's material or not. If you're the buyer, your hope is that the purchase agreement just referenced purchaser can terminate in the event of material destruction, period, at the end, because that wiggle room can be helpful. And so if you think that you're gonna have parties fighting over materiality, phone a litigator friend, let them know you might have a case for them, and sort of guide them through it as much as you can. Now, if everyone agrees that it is not material destruction, you want the sellers to start repairs immediately. I represented a buyer in an assisted living facility in Oklahoma, and as happens in Oklahoma, it got hit by a tornado a week before closing. Thankfully, it only hit a storage area. No one was hurt, wasn't material damage, but you had a building that had a hole in the roof and the wall, which isn't great. So purchaser wanted to go through with this deal, but they didn't want to pay for repairs, and they didn't want to have an active hole in the roof and the wall of the building. Again, that is a problem. So what we proposed and seller accepted was taking $500,000 out of the seller's proceeds, putting that into escrow. They would start the repairs immediately, and that money would be there to complete them post-closing. And an escrow really is the best way to deal with a problem like this. That probably wasn't a fun conversation for that seller's attorney to let them know that they were getting $500,000 less than they had planned for. But that tornado also could hit a week later, and it would have been their problem. So I think if you're in this situation, you've just got to emphasize to your client, it's truly random happenstance. Like, you've got to be realistic here. You might want a purchase price cut. You might not want to start repairing things, but if you want to get this deal done, you got to work with the other side to make it happen. All right, and so let's just say you got your documents into escrow, you found all your missing signature pages, the building flooded, but you still went to closing. And so now you're done. You are not actually done. The first thing you need to do after closing is create a closing binder. Remember, I mentioned that index earlier. You actually get to attach it to something. The binder will have not just the documents that got signed, but also the purchase agreement. Might have the letter of intent in there. Title policies and surveys if you're representing the buyer. leases and management agreements, those sort of things. You basically want to be able to tell the story of the deal in this binder. We usually send electronic binders now, either through a Dropbox link, or larger clients might have like their own extranet we upload them to. Back in 2012, when I was a paralegal, I was making hard copy binders, usually for the firm and also for the client. Now there are a few longtime clients who still get binders, but they've earned the right to be particular. Now, some clients are going to faithfully refer to that binder. You know they look at it whenever they have questions. Some are going to ask you every 6 months to send them a document that they definitely have access to. And even if you always resend that binder link, they're going to be back in another 6 months asking for it. So don't let that stop you from making the binder, though, because even if they don't look at it, it's good for you. When I talked about that client who got sued over a contract that they didn't assume, the reason I was able to pull out the assignment of assumption of contracts was because I had the binder. I was able to use it. So it's a good resource for yourself, even if the client's not necessarily going to use it. You're also going to want to calendar any post-closing dates. Similar with those ones pre-closing, you need to be on top of these. If they had repairs under an escrow agreement, they need to complete in a certain amount of time. You will want to calendar that and bug your client. If they need to true up the closing statement for those employee salaries, you need to bug your client to stay on that. You are basically going to be bugging your client a lot post-closing. Deals never truly end until like maybe 5 years later when the statute of limitations runs. So just make sure you stay on top of those critical dates even after the deal is done. And then finally, you should celebrate because you accomplished a great thing for your client and you probably learned a lot. You've expanded your own knowledge base on this. You definitely spent a lot of time on it. I recommend having your own little closing tradition. This is a restaurant really close to my office, Easy Bistro, if you're ever in Chattanooga. They have great roasted oysters and fries and martinis. And so I will go either with a friend or by myself, have that as my dinner, and just celebrate. Because a lot of times, it's a random Tuesday when you do this. And so, you gotta find a way to make it exciting. All right, so that is it. I talk fast, so you will be out of here early, but does anyone have any questions? Going once, going twice. All right, well, thank you all.